Is this a joke? Prosecutor Vanessa Crane's voice sliced through the packed courtroom, sharp enough to draw blood. Your Honor, are we seriously going to let a 19-year-old in a suit? He clearly borrowed play attorney. This isn't a debate club. A woman's freedom is on the line. And apparently we're entertaining a child's homework assignment. Julian Hale stood frozen at the defense table. The weight of 40 strangers' stares pressing down on him like a physical thing. Somewhere in the gallery, someone laughed. The judge exhaled through his nose. Everyone in that room believed the outcome had already been decided. They had no idea this kid was about to take the whole case apart. Courtroom 14 of the Cuyahoga County Court of Common Pleas smelled the way old courtrooms always smell: varnish, dust, and the particular staleness of 100 years of other people's worst days. Julian sat with his hands flat on a legal pad, gone soft at the corners from handling, his thin shoulders swallowed by a charcoal suit borrowed from his uncle. Beside him, his mother, Renee Hale, twisted a tissue into a tight rope between fingers that had gone permanently rough from a decade of double shifts behind a school cafeteria line. Renee was facing 15 years in federal prison. The charge, a sweeping conspiracy to commit wire fraud, the embezzlement of $480,000 from a regional small business relief fund administered by the city. It was an absurd accusation on its face. Renee Hale barely trusted online banking, let alone a six-figure digital heist, but the prosecution wasn't interested in the truth. They were interested in closing a case fast. And Renee was the convenient name attached to a financial mess that a corrupt member of the city council badly needed someone else to wear. Leading the charge was Vanessa Crane, a name that made defense attorneys in 3 counties visibly tense up. She had a conviction rate hovering around 91%, built on courtroom theatrics, surgical cross-examinations, and according to quiet rumors that never quite made it into print, a willingness to bend procedure until it nearly tore. She wore a deep maroon power suit that afternoon, a vintage gold watch catching the fluorescent light every time she gestured. And she moved through the courtroom like she already owned every square foot of it. Julian wasn't a lawyer. He was a college dropout, forced to walk away from a scholarship in mathematics and philosophy at Case Western Reserve University the week his mother was arrested and their accounts were frozen. With no money left for representation, Renee had been handed a public defender carrying a caseload of 140 clients. A man who'd urged her, almost apologetically, to take a plea deal that still meant 6 years behind bars. Julian refused. He had a memory that didn't forget things and a mind that processed dense systems the way other people processed small talk. For 6 months, he had lived out of the back room of a free legal aid clinic, where he'd once volunteered, sleeping on a cot surrounded by donated law books, devouring the rules of civil procedure, state statutes, and a century of case law most practicing attorneys never bothered to revisit. He'd found an obscure provision in the state constitution permitting a family member to act as a defendant's advocate when adequate counsel couldn't be secured. And he'd filed the petition himself. Judge Bernard Wickham, a tired man 18 months from retirement, looked down from the bench, his gaze moving between the polished composure of Vanessa Crane and the terrified mother beside her intense. Anders son, Mr. Hale, the judge said, not unkindly, but with the particular weariness of a man who'd seen this kind of hope crushed before. I've reviewed your petition. I admire the devotion behind it. But this is a complex financial case, and the prosecution has assembled a thorough record. Are you certain you wish to proceed? If you fail here, your mother faces the maximum sentence available. Julian swallowed. The room was dead. Silent reporters in the back row. The bailiff's flat stare. Vanessa Crane's open disdain. He looked at his mother. She gave him the smallest possible nod. I'm certain. Your Honor, he said, his voice cracking once before steadying. The truth isn't a debate club either. Sir. And the truth is, my mother is innocent. Crane let out a short laugh. Your Honor. Please. The defendant's credentials initiated the transfers. We have the IP logs. We have the financial trail. This boy is going to stand here and recite case law he found at 2 in the morning, while his mother's life hangs in the balance. The gavel came down, and the trial began. The first 3 days were an exercise in slow, deliberate humiliation. Vanessa Crane wasn't satisfied with simply winning. She wanted Julian gone. Wanted the courtroom to understand that the law was a closed club that didn't tolerate amateurs wandering in off the street. Every time Julian rose to cross-examine the prosecution's forensic accountant, Crane objected before he finished his sentence. Objection leading the witness. Objection hearsay. Objection. Your Honor. Counsel is citing a statute that hasn't been valid law in nearly 30 years. Judge Wickham sustained nearly all of it. Mr. Hale, he said more than once, rubbing his temples. You cannot simply recite a textbook at this court. The law requires interpretation. It isn't a vending machine. The jury watched with a mixture of pity and discomfort. Julian's questions, meticulously structured in his head the night before, kept getting derailed by procedural roadblocks. Crane threw up with practiced ease. She wasn't using the rules to find the truth. She was using them to bury it. The low point came on the 3rd day, when Crane introduced the prosecution's centerpiece, a stack of digital authorization logs allegedly showing Renee Hale's secure employee credentials, initiating the fraudulent transfers. Julian stood, his hands trembling slightly around a stack of server logs. He'd subpoenaed himself. Your Honor, I'd like to move to suppress this exhibit. I've reviewed the metadata. The timestamps don't match my mother's shift schedule. And the originating terminal. Objection. Crane Coutin, slamming her palm on the table. Is the defense attempting to qualify a teenage college dropout as a digital forensics expert? He has no certifications. No standing. This is a desperate attempt to drown the jury in jargon he found on the internet. Laughter rippled through the gallery. A juror smiled and quickly looked away. Renee buried her face in her hands. Shoulders shaking, Judge Wickham's gavel cracked down. The prosecution is correct. Mr. Hale, you're not a recognized expert. The motion to suppress is denied. Your Honor, if you'd just look at the raw, I said, denied. One more outburst and I'll hold you in contempt. I warned you this was a mistake. Crane walked past him afterward, leaning close enough that only he could hear. You should have taken the deal. Kid, I rest my case tomorrow. By the weekend, your mother's in a cell. Julian stood alone in the well of the courtroom as it emptied, the weight of the day settling into his chest like wet concrete. But underneath it, something cold and exact was forming. Crane thought she'd beaten him with the rules. She'd forgotten that he hadn't just memorized them. He understood the architecture holding them up. That night, he was going to find the load-bearing wall and pull it out. Rain hit the windows of the legal aid clinic's back office just after 11. Julian sat cross-legged on the floor, surrounded by a half-collapsed wall of case files, statute books, and printed discovery documents. His eyes burning from too much coffee and not enough sleep. He couldn't beat Vanessa Crane on procedure. She'd built her whole career mastering procedure. He needed to go somewhere she wouldn't expect the constitutional bedrock underneath the case entirely. He knew the digital logs were fabricated. He just couldn't get an expert witness to say so on the record. So instead, he set out to prove the prosecution's entire legal foundation was rotten. He found the first crack, reading through the city's civil forfeiture code, the same code Crane had used to seize his mother's home and accounts before any verdict had been reached, cross-referencing it against Timms v. Indiana, the real 2019 Supreme Court ruling, holding that the Eighth Amendment's protection against excessive fines applies to the states. He realized the seizure itself sat on shaky ground. But the statute Crane had used Ordinance 1187 required a mandatory federal magistrate review within 48 hours whenever a seizure touched funds tied to a federal grant. She hadn't done it. She'd routed it instead through a friendly local judge for a rubber stamp. It got worse. Buried in the discovery dump, 9,000 pages designed to overwhelm, was the IT department's internal correspondence regarding the city's server maintenance. On page 7300, almost invisible among routine maintenance logs, sat an email from the city's lead systems technician, Owen Castile, sent directly to Vanessa Crane's government account during the second week of February. Miss Crane, per your request, we completed a full audit of the fourth-floor terminal. We identified a remote access intrusion tool installed on the machine roughly 6 weeks before the transfers occurred. The originating IP traced through an offshore relay before bouncing back through our own network. Renee Hale's login credentials were not used by Renee Hale. They were stolen. Full diagnostic attached. Julian sat very still. His heart slammed once. Hard. Against his ribs. Crane had known. She had received documented, undeniable proof that Renee Hale was innocent, and she had buried it. A textbook violation of Brady v. Maryland. The real precedent requiring prosecutors to disclose any evidence favorable to the defense. This wasn't a procedural slip. This was a felony, but he couldn't just wave the email around in court tomorrow. Crane would call it a draft. Claim it was unverified. Bury it under another wall of objections. He needed to lock her into a lie. On the record, in front of the jury, and then let the lie collapse on its own. He spent the rest of the night building the trap, line by line. By the time grey light crept through the clinic's small window, the frightened, stumbling boy from the first 3 days was gone. What looked back at him in the bathroom mirror had the flat, settled calm of someone who'd already seen the end of the game. Word had spread through the courthouse overnight. By morning, courtroom 14 was standing room only law students. Off-duty clerks. Reporters who'd come expecting to watch a slaughter. Renee reached over and squeezed her son's hand under the table. "It's okay. Baby," she whispered. "You did everything you could. I'm proud of you, no matter what happens. I'm not done." "Mom," Julian said quietly. "Just watch." Judge Wickham took the bench. "The prosecution has rested. Mr. Hale, does the defense have any final witnesses before closing arguments? And I will not tolerate further procedural irregularities." Julian rose. "No legal path. No notes. Just a single folded page in his pocket, and a voice that, for the first time in 4 days, didn't shake at all. The defense calls its final witness." Crane rolled her eyes without looking up. "Who?" "The mailman. The defense calls lead prosecutor Vanessa Crane to the stand." The room went absolutely silent. The bailiff dropped his pen. Judge Wickham leaned forward sharply. "Mr. Hale, you cannot call opposing counsel as a witness. That's almost entirely prohibited under the rules of professional conduct." Objection. Crane was on her feet, color rising in her face. "This is a stunt. Your Honor, I want him held in contempt immediately." "Your Honor," Julian said, unfolding the page. "I'm invoking the provision, allowing the calling of opposing counsel when that attorney holds material, non-privileged information central to an allegation of prosecutorial misconduct. If Miss Crane refuses to take the stand, I'll move for an immediate mistrial with prejudice, based on a deliberate Brady violation involving suppressed exculpatory evidence." The phrase landed like a dropped weight. Brady violation. The worst accusation a defense attorney could level at a prosecutor. Judge Wickham studied Julian for a long moment. Seeing him for the first time. The boy wasn't floundering anymore. He was entirely, frighteningly composed. "Miss Crane. The judge said slowly, "Are you aware of any exculpatory evidence not yet disclosed to the defense?" "Absolutely not." "Your Honor." The lie came out smooth. "Practiced. This boy is fishing. He has nothing. Julian, let it sit for a beat. Let the record reflect that Miss Crane has stated under oath she is aware of no exculpatory evidence." He walked 3 steps toward the center of the room. "Your Honor, I'd like the court to review Defense Exhibit 19. He handed a folder to the bailiff, who passed it to the bench, then handed a copy directly to a suddenly pale Vanessa Crane. Exhibit 19 is a time-stamped email from the city's lead systems technician, Owen Castile, sent to Ms. Crane's official government account during the 2nd week of February. It contains a diagnostic report proving the originating IP address used in the fraud was a spoofed offshore connection routed through a remote access tool. The report states explicitly that my mother's login credentials were stolen, not used by her. The courtroom detonated. Reporters scrambled for their phones. Renee gasped, hands flying to her mouth. That's inadmissible." Crane snapped, her voice climbing. "He must have accessed my email illegally. That's a federal crime." "I didn't access anything illegally," Julian said evenly. "I subpoenaed the IT department's maintenance communications. It was buried on page 7,300 of 9,000 pages of discovery you handed me, hoping I'd never get that far. You hid the needle in the haystack. Ms. Crane, you forgot I'm very good at finding needles." Judge Wickham was reading the email himself now, his face darkening by the second. "Ms. Crane, is this document authentic?" It was inconclusive. She stammered. "We didn't believe the methodology held up. You don't get to decide that," Wickham said, his voice finally rising to something close to a roar. "It's not your job to evaluate whether exculpatory evidence is convincing enough to share. It's your job to turn it over. This is a textbook Brady violation. And you know it. I'm not finished." "Your Honor," Julian said, his voice dropping lower now, steady as a held breath. "Because this isn't only about the suppressed email. It's about Ordinance 1187. He moved to the podium. "Under that ordinance, Ms. Crane seized my mother's accounts and our family home before any verdict was reached. Under Tim's Veer, Indiana. The 8th Amendment's protection against excessive fines applies fully to state and local civil forfeitures. Seizing a family's home over a crime the prosecutor already knew my mother didn't commit isn't just excessive, it's a deprivation of rights under color of law. Actionable under federal civil rights statute, and Ordinance 1187 requires mandatory federal magistrate review within 48 hours whenever federal grant funds are involved. Ms. Mate, Crane bypassed that requirement entirely, routing the seizure through a local judge instead, because the underlying request relied on deliberately withheld evidence. The seizure itself is unconstitutional." He turned to face the bench fully. "I'm asking this court not only to dismiss all charges against my mother, but to declare Ordinance 1187 unconstitutional as applied, and to issue an immediate injunction, returning every seized asset." The room had gone past, shocked into something closer to stunned silence. In under 15 minutes, a 19-year-old, in a borrowed suit, had exonerated his mother, exposed felony-level prosecutorial misconduct, and was now systematically dismantling a city ordinance that had quietly devastated low-income families for years. Crane gripped the edge of her table. Knuckles, bone white. "You can't do this," she whispered. "The law isn't a debate club." "Ms. Crane," Julian said, echoing her own words back at her. "You treated justice like a game you'd already rigged. You just got checkmated." Judge Wickham sat back, removed his glasses. and pressed his fingers against his eyes for a long moment. When he finally spoke, his voice carried the full, quiet weight of the bench. In nearly 30 years on this court, he said, looking at Julian with something close to awe, I have never witnessed a more serious abuse of prosecutorial power, and I have never witnessed a more precise dismantling of a case by anyone, let alone a teenager representing his own mother. He lifted the gavel. All charges against Julian Hale are dismissed. With prejudice. They cannot be refiled. The court grants the defense's motion for an immediate injunction, restoring all seized assets, and the record will reflect this court's finding that Ordinance 1187, as applied here, is unconstitutional. His gaze shifted to Crane, and any trace of warmth disappeared. As for you, Miss Crane, you are removed from this case, effective immediately. I am referring you to the State Bar for disbarment, and forwarding this transcript to federal prosecutors for review of civil rights violations under color of law. The gavel came down. Case dismissed. The courtroom erupted. Renee collapsed forward into her son's arms, sobbing into the shoulder of his oversized borrowed suit. You did it. My boy. You actually did it. Julian Hale. The cold precision of the last 6 months finally cracking open to let the relief through. We're going home. Mom. Across the room, Vanessa Crane stood frozen as 2 bailiffs who had spent years taking her orders approached her instead. Ma'am, one said, without a trace of deference left in his voice. We need you to step away from the table. The judge wants you held pending the federal review. She looked at Julian once, and whatever had lived behind her eyes for the length of the trial, the certainty, the contempt was simply gone. Outside, the rain had finally broken, and a strip of pale sunlight cut across the courthouse steps. Reporters who had come to watch a teenager get humiliated were now shouting questions at him instead. Julian, how did you find the email? Are you going to sue the city? What's next for you? He paused at the top of the steps, his mother beside him, smiling for the first time in over a year. I'm not interested in being famous, he told the cameras, his voice calm. I wanted to save my mother from a system that forgot what it was supposed to protect. The law is supposed to be a shield for people who can't defend themselves, not a weapon for people who already have power. And when the people holding that power forget it, he looked directly into the lens. Somebody has to remind them. Within weeks, the fallout reached far beyond Crane. The federal review into her conduct led investigators straight to the city councilman who had orchestrated the original fraud to cover his own financial trail. He was indicted within the month. Crane, facing years in federal prison herself, agreed to cooperate. Ordinance 1187 was rewritten from the ground up, citing the case now informally known around the courthouse as Hale v. 2, City of Cleveland, as the reason thousands of families could no longer have their homes seized without due process. As for Julian, the story didn't stay local for long. Stanford Law School's dean called him personally within the week, offering a full scholarship and waiving the undergraduate degree requirement entirely, citing his courtroom performance as unlike anything the admissions committee had ever reviewed. He accepted. He had walked into that courtroom a boy in a suit that didn't fit him, dismissed before he ever opened his mouth. He walked out of it, something else entirely proof that the system meant to crush people who couldn't afford to fight back had, instead, handed one of them the exact tools to take it apart.